What's up, guys, and welcome back to Wake Up Entertainment. So, as you all know, in court, there are these two sides, the state and the defense. And what the state does is that they bring their own evidence forward. And when they bring their evidence, their duty is to try and prove that the accused before the court are guilty. And the job of the defense itself is to try and prove that the state is wrong by also presenting their own evidence, or even calling their own witnesses. So after hearing both these two sides, that's when the judge then makes his decision based on who presented, a strong case. So what happens in court, during cross-examination, the job or the responsibility of the defense is to try and expose the state, by revealing these inconsistencies. What then happens is that when the state, through Advocate Baloyi, have been caught off guard, they then call for the adjournment, sort of like running away from the cross-examination or trying to, to disturb the flow of the defense itself. We've seen it happen so many times, calling for these adjournments by Advocate Baloyi, running away. So at the Senzo meyiwa trial, there's something interesting that happened, and the defense was exposing these inconsistencies. And so these are some of the inconsistencies that were revealed by the defense during the Senzo meyiwa trial. And then there's something interesting that actually happened at the end of the video. So I want you to listen to these inconsistencies and stay all the way up to the end, where it got really exciting in courtroom, So what happened is that the defense, was trying to weaken the testimony of the state witness and the reliability of the evidence being presented. So the first point that I saw was that of selective and potentially biased, data presentation. That's what the defense was trying to do. So what happened is that the state witness that was brought by Advocate Baloyi, he actually admitted to not presenting a direct copy of the police central database in their table, that is Exhibit 01. They chose a specific data points, they deemed relevant. So the exposure now came in the part that this selective approach, it opens the door to the argument that the witness may have omitted crucial information that could contradict their conclusions or support the defense case, So it suggests a potential bias in how the data was presented to the court. So another point, it is the creation of an intermediary analysis layer. So instead of really relying solely on the raw data from the police and the service provider, the witness created their own spreadsheet and table. So this intermediary step, it introduces a layer of the witness interpretation and how they worked with this data. So what I can see here, the defense now, is that they can argue that this process allowed for errors, compared to the original data or those of unaltered records. These are some of the inconsistencies, with the state witness. So moving on, there was a problematic application of the 2-hour rule. I once talked about this thing of the 2-hour rule, there's this difference in time zones, If you go to Australia, they have their own time. Here in South Africa, we have our own time. In USA, they have their own time. So these time zones, they make the time to be different. So what happened is that the defense, they used specific examples, 2 August and 15 October, to highlight how this 2-hour rule leads to discrepancies and contradictions when comparing the witness table with the GPRS records. So the application of the 2-hour rule to the timestamps was said to be inconsistent and unexplained. and there was inconsistency and missing data across exhibits. So key points, like code duration and specific cell names were present in some records but absent in others. For example, missing in exhibit 2PK5C and the GPRS stream. Obviously, these inconsistencies, they cast doubt on the integrity and correlation of the evidence. Obviously, the defense would argue that the events are related. The data should be consistent across all records, and the missing information, it further weakens the witness analysis. Yeah, but moving on, the witness denied any knowledge or involvement with exhibit triple K5, stating they didn't work on it and didn't know how it ended up in the court. So this raises questions about the authenticity and provenance of this piece of evidence. It suggests a potential mishandling of evidence or the introduction of unverified documents, obviously further damaging the credibility of the presented information. Another thing that happens, I'm trying to find out this quote where it says, if you repeat a lie enough, some people end up thinking that, oh, this is the truth. So there's this allegation of repetitive and unnecessary testimony where the defense was accusing the witness of simply repeating the testimony already given in a previous hearing regarding the manipulation of phone number formats for the analyst notebook program. So they were suggesting that the witness' current testimony might not be introducing any new or relevant information potentially aimed at reinforcing a previously challenged narrative without adding any substance. So they were saying that the defense was saying this witness is repeating what they testified about, but what they testified about was challenged and proven already, and holes were already poked in that evidence. So by repeating that evidence, it's sort of like that reinforcement, that I talked about, whereby if you are the judge, you may be confused, because you're a human being. You may start to believe that, oh, this is actually true. So this was the challenge, by the defense in saying, no, you can't be repeating what we already challenged you on. So these were the inconsistencies that were being revealed by the defense. So with all of these inconsistencies being revealed, this is where those adjournments, start being called, and each side then goes, to try and see where exactly they missed it and how this inconsistency is not adding up, because it's a battle. This job, it involves a lot of work in it. So tell me what you think in the comment section, and I'll catch you guys on the next one.